Two important deadlines every California landlord needs to know for the California rent control bill. And if you're not careful, you can lose your exemption if you have one. Hey there, Christian Walsh, Coldwell Banker Wire Associates. We specialize in multifamily, single-family leasing in Orange County. It is June 3rd here in lovely Orange County, and we have an update related to AB 1482. Deadlines are coming. In fact, less than a month away, July 1st, 2020, we have an important deadline coming, and we're here to share with you what you need to do as a landlord. And this is all landlords. So some properties are exempt from this bill, but all landlords have to do this. So AB 1482, officially known as the Tenant Protection Act of 2019, also known as the California Rent Control Bill or Rent Cap Bill, went into effect on January 1st, 2020, and essentially specifies two things. One is for properties that the bill applies to, the amount of rent increase given in a year is capped at 5%, plus the consumer price index, and in no cases higher than 10%. The second thing it specifies is that evictions must be for just cause. In the case of a just cause eviction, such as an extensive remodel of a unit, or the landlord tends to move into the unit, there would be relocation fees that the tenant is owed in those cases. So those are the two things that the bill specifies. There are some important deadlines that are coming up. So July 1st, 2020 states in the bill that any new tenancies signing a lease or rental agreement after July 1st, 2020 must have mandated language in the lease when they sign. And we have that mandated language. If you don't have it, reach out to us for disclosure and we'll get it to you. The second thing it says is that all existing tenancies must be given notice, must be given this mandated language before August 1st, 2020. So there's some important deadlines there. You basically have a month after July 1st. So you have until August 1st for all tenancies in place before July 1st. And once July 1st hits, you have to be giving this mandated language. Now here's where it gets interesting for exempt properties. So which properties are exempt from this bill? And what do I mean by exempt? What that would mean is the owner could raise the rent as much as they want in a year, and evictions would not have to be just for just cause reasons. A landlord could ask a tenant to move out with proper notice for essentially any reason. So those exempt properties are single family, townhomes, condos. Those are all exempt. It's duplexes where the owner lives in one unit. They must not be owned by a corporation. If it's an LLC, there can't be a major corporation in there. It's for all the other properties, so non-owner occupied duplexes and larger. If it's 15 years or younger, the bill doesn't apply as well. So the property is exempt, and that's a rolling deadline. So in 5 years, it's still 15 years back. So you could see if the property's 14 years old right now, when it hits 15, the bill applies. So if you're an owner, you want to make sure you keep your exemption. Let's say you have a building that's 10 years old and it's got 150 units. You want to keep that exemption. Or you're a landlord who owns a house and you want to keep that exemption. You must give the state mandated language by August 1st for existing tenants that have been there since before July 1st. And this is the little loophole that most people aren't catching. If you're putting a new tenant in there after July 1st, you got to make sure you're giving them that mandated language. You're not going to get a free pass. Oh, hey, July 15th, sorry, I forgot to give you this. Here, let me catch you up. Because the bill specifically states anything after July 1st, they have to be given the language at the time they sign. Any tenancies that existed before that time, you have up until August 1st to give those notices. And there's nothing that prevents you for existing tenants giving them the notice today in June. In fact, I highly recommend it. And then same thing, if you're signing a lease or rental agreement with a new tenant in June, put it in the lease or the rental agreement. So that's my advice. And this is for all landlords. So whether your property is exempt or not exempt, there's specific language you must deliver. And there's additional bills that are coming down the pike that are helping give some more teeth to AB 1482, including a fine for landlords who don't follow the bill mandated steps. So you don't want to mess around with AB 1482. So make sure you are following those guidelines. You can reach out to us to get you the disclosure, to get you an addendum that has the state mandated language. Christian Walsh, Coldwell Banker, Wire Associates, 949-677-3466. We're here to help. Please subscribe to our channels, subscribe to our weekly newsletter, because we've been telling our clients about, our newsletter subscribers about this. And please leave your comments below. What are you seeing out there right now related to California's rent control bill? Thanks for tuning in, much appreciated. We'll keep the good content coming. Take care.